on April. Can you stop talking? Thanks. Appreciate it. If you want to talk, that you can always go outside. It's April 21st, Tuesday. We're going to have some hearings by affidavit, and then we're going to go into a contested hearing between Avant and Permian Resources. I'm going to call some of the hearing by affidavits first, since they should be simpler. I'm going to start with case 25947. This is an amendment filed by Marathon. I think we're here again after hearing this case for the first time a little while ago. Entries of appearance, please.
Good morning, Mr. Hearing Officer Adam Rankin with the Senate Office of Holland Hart, appearing on behalf of Marathon in both cases.
Both cases?
I can do one at a time. That's fine. Yeah.
Okay.
Yeah. In this case, Mr. Hearing Officer, there was
There are no other parties?
not to my knowledge.
Okay, very good. Go ahead.
And this is a case, Mr. Hearing Officer, where notice needed to be perfected for two additional parties, actually one additional party, Carnegie Energy LLC. We revised the hearing packet previously and submitted showing that notice was timely provided to this party, and now time has lapsed and notice has been perfected to that party. And the exhibits reflect that certified mail was sent to Carnegie and they have been advised timely.
Okay. So so I'm gathering, because I'm not looking at the actual imaging system at this moment. So you filed an amended exhibit packet with that additional notice?
Correct.
Okay, thank you. So that's admitted into evidence without exception. And let's see, is it Mr. McClure? Are you the hearing technical examiner for that case?
Yeah, for the first two cases I am, and we can take them under advisement.
Fantastic, thank you. Okay, so you heard, Mr. Rankin, that we're going to do the same for the second case, but I'm going to call it anyway because I haven't called it yet. 25949.
Thank you, Mr. Hearing Officer. Again, Adam Rankin with Holland Hart, appearing on behalf of the applicant Marathon in that case. Same situation, same party, has been provided notice timely, and notice has now been perfected for that party, and it's reflected in the revised hearing packet.
The exhibits are admitted without exception. The case is taken under advisement. Thank you, Mr. Rankin. Let's move on now to case number 3 on the docket. That is a compulsory pooling application on behalf of Devon Energy 25984. Entries, please.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen and Shield, appearing on behalf of Devon Energy Production Company.
Thank you. Mr. Savage, do you know if there's any other parties?
No, there's not.
Go right ahead.
So this was this is a follow-up to a previous hearing, and we needed to do an amended hearing packet. The items that we addressed were revising the checklist to include all necessary boxes and entries. We updated the information regarding Colgate's waiver of notice. We also included a email noting that waiver, and then we removed EGL resources from the pooling list because they're a non-participatory record title owner, and that basically covered everything. And I believe that Technical Examiner Fordyce is the examiner for this.
Have you submitted new documents showing that?
Yes.
Okay. So then your new exhibits are admitted without exception and the case is taken under advisement.
Yeah, thank you.
Thank you. Let's move on to case number 4. This is a non-standard unit and compulsory pooling application submitted by Avant 25986.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2 LLC.
Are there any other parties?
There are Mr. Rankin and Holland and Hart entered an appearance on behalf of MRC Permian.
Mr. Rankin.
Thank you, Mr. Hearing Officer. We're just tracking this case. Thank you. Sure. Apologize. Adam Rankin appearing on behalf of Matador in this case with the law firm of Holland and Hart. With the law firm of Holland and Hart.
With the law firm. I wasn't sure if you said you withdrew something or. Okay. Ms. Bennett.
Thank you very much. This case is a continuation of a hearing that was held on March 26th. And at the March 26th hearing, the technical examiner asked that Avant make certain revisions to its exhibit packet. And as reflected in the notice of revised exhibit packet, we have made those revisions, and we timely filed the revised exhibit packet. And so with that, I would ask that the exhibits in case number 25986 be admitted into the record and the case taken under advisement.
Granted.
you.
Admitted without exception, taken under advisement. Thank you. Let's move on now. I think this is a new case. It's case number 5 on our docket. I don't believe it's attached to any other case. This is 25813, compulsory pooling, overlapping spacing unit, Coterra Energy.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating. And originally, Ms. Luck had entered an appearance in this case on behalf of ICFIS, but has since withdrawn their competing application and objection to the case moving forward by affidavit.
So this is a new case then.
It is, and it was originally set for today's hearing for a contested hearing. And with the division's grace, we were allowed to come to hearing today, given some lease expiration issues.
So let's do this. We have Ms. Kessler. Let's hear from Ms. Kessler.
Good morning, Mr. Examiner. Jordan Kessler with EOG Resources, and we're just monitoring this case.
Thank you, Ms. Kessler. And Ms. Luck, did you want to enter an appearance?
Oh, I just wanted to confirm Caitlin Luck for ICFIS Energy and Ms. Bennett correctly provided. We have dismissed our application and withdrawn the objection to this case. Thanks.
But you're still maintaining your appearance.
Yes, I'm here today for ICFIS. Thank you.
All right, perfect. Thank you, Ms. Luck. So, Ms. Bennett, Mr. McClure had a lot to review for today's. So we will get to your case, but after lunch today. So we'll hear by affidavit at that time.
Sounds good.
All right, sounds good. So,
Thank you.
And I don't know what time lunch will be, but you'll remind me to take up that case?
Yes, I will. And I'll just need to confirm with my witnesses that they're available after lunch, which I will do on a break.
Sounds good. I just know that the exhibits have not been reviewed.
Okay.
At this point, now, if we come back tomorrow, we could also, if your witnesses are not available till tomorrow, we can hear it then by affidavit as well.
Perfect. I'll make sure that they're available either after lunch or tomorrow.
All right, thank you.
Thank you.
We're off the record in that case, but we're in recess on that case. Let's call case number 6 on our docket, 25951. This is an exception to the well density requirements by Hillcourt.
Good morning, Mr. Hearing Officer Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the applicant Hillcorp in this case. To my knowledge, there are no other parties who have appeared.
So, Mr. Rankin, just so you know, this is a new case, if I'm correct.
That's my understanding. Yep.
And the same thing goes for this case than the last case, which is that the technical examiner has not had time to review the exhibits yet and will be able to take this case and hear it by affidavit either after lunch, if your witnesses are available, or tomorrow morning at whatever you decide.
I'll have to confer with my witnesses to make sure of their availability and report back, hopefully before the lunch hour, just to make sure that they're available. But I think either option should be suitable.
Perfect. And thank you for your understanding, both of you. Okay, let's move on to number 7 on our docket, 258. Well, so we're in recess on 25951. Let's move on to number 7 on our docket. This is Avant operated. We have a contested hearing today. Avant has, let's see. Well, why don't I do it this way, since it's on so many different pages of paper at this point. We have a contested hearing with Avant and Permian Resources. Avant, would you like to enter an appearance and give me your case numbers?
Yes, good morning, Mr. Hearing Examiner, Mr. Technical Examiner, Dina Bennett on behalf of Avant Operating LLC. And the Avant cases are numbers 25827, 25829, 25831, and 25832.
Perfect. And now to Permian Resources.
Good morning, Jackie McLean and Dana Hardy on behalf of Permian Resources. And our case numbers are 25833 through 25845.
Thank you. And you have co-counsel?
Yes, Ms. Hardy.
Would you like to enter an appearance?
Oh, Ms. McLean entered appearance for me, but Dana Hardy also on behalf of Permian Resources.
Thank you. I must have missed it. I apologize.
It's okay.
Are there any other parties?
Yes, good morning, Mr. Hearing Officer Miguel Suaza with Beatty and Wozniak, appearing today on behalf of Coterra Energy Operating Company, Magnum Hunter, and Cimarex Energy Company in each of the cases that the the other counsel has listed for the record, which I can list for the record.
So you're saying all the cases?
Yes,
Okay, perfect. And I thought you entered an appearance yesterday, didn't you?
I did. Yes.
Okay, good. And your appearance was titled what?
Well, we're primarily just monitoring these cases. We're not going to be asking questions or anything like that, but we did want to express our support for Permian Resources applications simply because we think that they're more efficient and effective, and they also develop Coterra's, acreage. So for what it's worth, we do support that, but other than that, we're monitoring only.
Thank you. Are there any other entries of appearance?
Yes, good morning. This is Jordan Kessler on behalf of EOG Resources. We're actually only an offset party in this case, so we did review the exhibits. We don't have any questions. We're monitoring but taking no position.
What does it mean an offset? I think you muted yourself.
I think somebody muted me. Can you hear me now?
Oh, I can.
Okay, great. EOG does not own in the tracts that are being compulsory pooled, but we're given notice by virtue of the request for non-standard spacing unit. So we do not actually own in the compulsory pooled tracts and are not taking a position.
Perfect. Thank you for the clarification.
Thanks.
All right.
Mr. Hearing Examiner,
I'm sorry.
before we begin, I also wanted to introduce my co-counsel,
By all
Jeff
means.
Goodwin. He's with the law firm of Model Sperling, and he's here with me as well.
I think I've met you once before.
Yes.
Excellent. Welcome. I have been handed from Permian Resources a notebook with their exhibits beautifully labeled, as we really appreciate that they do, and the rebuttal exhibits. Miss Bennett, did you have something similar? You do have something similar. Okay. Thank you. Are your rebuttals in here as well?
Yeah, this is all of the exhibits.
When you say all, do you mean all of yours or all of everyone's?
Everyone's.
Everyone. So I have everyone's. All right. All right. Well, thank you very much. So I've been handed a notebook from Avant with their exhibits, their rebuttal exhibits and Permian's exhibits, but I think I'll just keep them separate. Okay, but thank you for that. I think the way I'd like to proceed is, first of all, to ask the parties, have they discussed who's going to present their case in chief first? And I see nodding, so that means yes.
Yes, I discussed with Ms. Bennett, and Avant is going to go first.
Okay, Yvonne's going to go first. Excellent. Miss Bennett, before we get to witnesses and exhibits by stipulation, et cetera, are there any preliminary issues?
I had intended to address Coterra's late filed entry of appearance, but given that Coterra does not intend to cross-examine the witnesses, then that is no longer an issue. I did want to just raise perhaps some efficiencies in the hearing today, or an ordering of the witnesses in terms of their direct and our rebuttal, and then reviewing Permian's rebuttal. And in the past, I know that contested hearings have gone in that order, where one witness does his or her direct, then reviews his or her rebuttal, and then we could then review his or her review of Permian's rebuttal in my case. So that's what I'd like to suggest in terms of ordering for the testimony, but of course, I'm only suggesting that.
Okay. Ms. McLean?
I appreciate the way that you've been handling the cases recently, which is the first witness will get up, they'll do very limited direct since we have pre-filed testimony, and really just essentially doing their rebuttal exhibits and testimony. And then we would have the ability to cross.
Mm-hmm. I think the parties are basically saying the same thing. I'll keep doing what I have been doing, and if there's an objection to it, please let me know and I'll consider it by all means. We have to be fair to everyone. Due process extends to both parties in the same equal manner. Both have filed applications with us, and okay. So today our technical examiner is Dean McClure. Mr. McClure, are you prepared to begin?
Yes, I am, Mr. Hearing Examiner.
Thank you. And have you had an opportunity to review the direct exhibits and the rebuttal exhibits from both parties?
I reviewed the direct exhibits. I have not reviewed the rebuttal exhibits.
Perfect. Well, I guess you'll get familiar. So parties and witnesses, you've heard that Mr. McClure, and when he says he's reviewed them carefully. So you don't have to worry about he's missed something. So we're going to ask you to give brief summaries of your direct testimony. You can get into your rebuttal testimony a bit more because he has not had an opportunity to review them yet. And then the cross-examination will bring out more, and then the redirect. You'll have plenty of opportunity to make your point today. I didn't ask you if there were any preliminary issues on behalf of Permian.
Nothing from Permian
Okay,
Resources.
thank you. Okay, so now let's see about stipulation to exhibits. So I'll start with you, Ms. McLean. Which Avant exhibits, and please be specific, it's for the record and for the court reporter, are you willing to admit through stipulation?
Permian Resources is willing to admit all exhibits and rebuttal exhibits with the exception of rebuttal exhibit C5.
C5, C
yes.
is Charlie 5?
Correct.
Okay. So then I am going to admit into the evidentiary record all of Avant's exhibits with the exception of rebuttal exhibit C5. Did I get that right?
That's correct.
Okay. Let me take some notes here. Ms. Bennett,
Thank you.
the same question.
Yes, thank you. With respect to Permian's direct testimony, Avant is willing to stipulate to the admission of all Permian's direct testimony, subject to lines of questioning that may show that the testimony or the exhibits are unreliable or irrelevant.
Okay, so then I'm going to admit all of Permian's direct exhibits. Now, when you say direct exhibits, do you mean the rebuttal exhibits as well?
No,
No.
with respect to the rebuttal exhibits, there are some issues with Permian's rebuttal exhibits, and so we are not willing to stipulate to several of their rebuttal exhibits.
So can you be specific so I
Yes.
can admit some of the rebuttal exhibits, or are you not willing to admit any of the rebuttal exhibits?
At this point, the only one haven't noted an objection to is C13 and C14.
I didn't hear you. Will you say it again?
C13 and C14 are the only two that I do not have an objection to.
I thought I heard something 13 and then D14. Say it
Sorry,
again.
C13 and C14.
Thank you. All right, so those you are willing to admit?
Yes,
All right, so let me put down C13 and C14 are also admitted by stipulation. So, Ms. Schoenberg, what? Okay. Oh, just to be clear, and when we say direct exhibits, is there, Ms. McLean, for the exhibits that are not rebuttal exhibits, what are you going to call them?
Well, we labeled our exhibits in consecutive order. So
Oh, okay.
it's just A1 through 13, B1 through, so it's very easy. We'll just call them B1, 2, 3.
All right, very good. So let me get your table of contents. Yes, there is one here. Thank you, by the way, for the table of contents. So what has been admitted by Avant through stipulation of Permian's exhibits are A and then A1 through A12. Right, Ms. McLean? Okay.
Correct.
Exhibit B, B1 through 20,
Correct.
C, C1 through C11, D, D1 through D9, and E, E1 through E4. And then also rebuttal exhibits C13 and C14. The other rebuttal exhibits are not yet admitted through stipulation, and we'll have to go through the usual foundation, and any kind of objection will be dealt with at that time. All right. Fine. Let's see. How many witnesses, Ms. McLean, do you have?
We have 4 witnesses.
Let me write this down. And Ms. Bennett, how many witnesses do you have?
Thank you. We have 3 witnesses.
3?
Yes.
3.
And they've all previously testified.
Okay, very good. They've all previously testified as experts in their field.
Yes, they have.
Okay, and Ms. McLean?
For Permian Resources, everyone has testified except for Hank Higginson, and he will need to be admitted as an expert.
Fine, we'll deal with that right off the bat then. Could I have all 7 witnesses come up to the witness stand, and would someone turn on the microphone? Thank you. Yeah, you've done this before. I recognize you. All right. Well, why don't we start here and we'll just move down the list. Are you with Avant?
Yes.
Okay, are all the Avant people together? Okay, perfect, right here. All right. And I recognize all of you, so I know that you testified here before. What I'd like everyone to do is raise your right hands, please. Thank you. Do you all swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Yes. Okay. Now, starting with you, would you state and spell your name for the court reporter, and then tell me if you've, and I know you have, but if you've previously been admitted as an expert by this division and in what field that is?
Sure. My name is Shane Kelly, ShaneKelly, and I have previously testified as an expert in the field of reservoir engineering. Reservoir engineering. Yeah.
Thank you. So now you can just go back and sit down for now. Thank you.
My name is John Harper, JohnHarper, and I previously testified in front of the division in my expert witness for petroleum geology.
And my name is Tiffany Sorrentinos, Tiffany, Sorrentinos, Sarrantinos. And I have also previously testified with the division in land matters.
Perfect. Thank you.
Yes.
And now we're going to hear from Permian's Permian's witnesses. Go right ahead.
Davro Clements, that's DAVROCLEMENTS. I have previously testified in front of the division as an expert in facilities engineering.
Name is Chris Canton. It's CHRISCANTIN. I have previously testified before division and under geology matters, petroleum geology.
Mark Haddock, MARK, HAJDIK, and I have previously testified before this division as an expert in land matters.
Thank you.
Hi, I'm Hank Higginson, HANKHIGGINSON. I have not testified before, but I intend to as a reservoir engineer.
Why don't you have a seat?
Okay.
I have a feeling that Ms. McLean has given me a CV somewhere in the documents, but I'm not going to look at that right now. But thank you for providing that. Reservoir engineer.
Yes, sir.
All right, sounds good. And make sure that you speak close to the microphone because she's
Yes, sir.
she's going to have trouble if you don't. What education do you have? First of all, what does a reservoir engineer do?
A number of things, risk management, understanding risk of assets, asset development, risk evaluation, financial and economic evaluation of assets for development. Also works in tandem with other disciplines within oil and gas, oftentimes so with mineral land to work out trades and other dealings with other operators as well.
Okay. And what education do you have? Just give me the degrees and the dates you earned them and where you earned them.
Yes. I have a Bachelor of Science in Petroleum Engineering from the University of Texas. I earned that in 2018, May. I'm currently pursuing a MBA, Master's in Business Administration from Indiana University, expecting to graduate in late 2027.
you said Indiana University?
Yes,
Okay. And who are you employed with now?
Permian Resources.
Permian. Okay. And when did you start working for Permian?
November of 2024.
Who did you work with before Permian?
Endeavor Energy Resources.
Okay. And for what years?
From when I graduated, so June 2018 until October 2024.
Okay. And what did you do for Endeavor?
Endeavor, I was a production engineer for the majority of time, and then for around a year or so at the end, I was a reservoir engineer. So
Okay.
2 roles, high, from a high level.
Okay. What's the difference between a production engineer and a reservoir engineer?
They evaluate different portions of the business. So the reservoir engineer essentially from an engineering standpoint, begins the evaluation process, determines which wells to drill, where to drill them, calculates expected returns as a result of those drilled wells, while factoring in risk, as I mentioned before, as well as any economic inputs. On the production side, they essentially handle whatever wells the reservoir engineer proposed. And so they then produce those wells once they're online, optimize them as they should and as they can, and also try to mitigate costs while operating wells in the most environmentally and safety conscious way.
So it sounds to me like a reservoir engineer evaluates a wider scope of issues than the production engineer?
It depends on the specific role. The economic aspect has potentially a wider or a higher level of impact on an organization individually, but a production engineer has a lot of unique and nuanced projects on a daily basis to work on. So not literally, but essentially production engineers putting out fires. But a production engineer is working on a number of projects at a wide variety at essentially all times, while a reservoir engineer has larger capital projects that generally will take a longer time to evaluate.
Okay, I understand. And now at Permian Resources, what's your job title?
Senior reservoir engineer.
And okay, are there any objections?
No objections. Thank you.
Wonderful. From here on in, the division sees you qualified as a reservoir engineer, also as a production engineer. So
awesome. Thank you.
There you have it. So anyway, you can go back and sit down. Thank you for your testimony. Okay. Is there anything else from Permian at this time before we start with Avant?
Nothing at this time.
All right, very good. Ms. Bennett, in what order do you want to call your witnesses?
Thank you, Mr. Examiner. I would ask leave to present a brief opening statement.
By all means.
And then I intend to call the witnesses in the order of land, geology, and reservoir engineering.
Okay, please go right ahead.
Thank you. The Avant and Permian cases involve a somewhat unusual set of competing cases. They both have proposed cases, both Avant and Permian, that cover Section 23 only. And they have also proposed cases that cover Section 23 in the north half of Section 26. And that's important because the ownership here is really key. And the ultimate issue for the division to decide is who should be operator as between Avant and Permian. And as I'll discuss in more detail, Avant should be awarded operatorship because Avant does have a majority working interest owner in both the Section 23 units and what I'll refer to as the 1.5 mile units, which are the 23 and north half of 26 units. And Avant's ownership is not just the majority, it's dominant. And so they should be awarded operatorship under the division's precedent. Avant is also proposing more wells across more benches than Permian. And so Avant's development plan will prevent waste and protect correlative rights. And Avant is a prudent operator and has a lot of experience in this area and is ready to drill these wells. I want to just talk a little bit more about the working interest ownership for a moment. Avant has the highest and the majority working interest and working interest control, no matter how the division looks at this. Avant provided testimony showing that Avant has in Section 23, I think 95 or 94% working interest. In fact, Avant just acquired another interest, is working on acquiring another interest to add to its working interest control, which will bring it up to 94.1%. And so that's the difference between Avant's ownership and Permian's ownership in section 23 is over 90%. So it's clear that Avant has not just the majority, but the dominant ownership in section 23. And looking at the 1.5 mile cases, Avant again has the majority and a significant increase over Permian's working interest and working interest control. Avant has now will have 64.04% due to the pending acquisition of the trainer interests. And this is 30% more than Permian's. So this is a significant amount of a significant difference between working interest control between the two parties. And Permian in its exhibits advanced an argument that Avant's working interest control numbers were inflated, but Permian's exhibits are actually based on a hypothetical future scenario that has not come to pass. Avant's exhibits are based on today's record title, and that is the record title that that Avant believes the division should consider. Even if the division, though, does accept Permian's invitation to review the more hypothetical ownership amounts, Avant still has the majority interest and still has a dominant interest. Even under that scenario, Avant's ownership is so much greater than Permian's. It ranges from 20% in the 1.5 mile wells to 75% greater than Permian's in the section 23 wells. And that is in line with awarding Avant operatorship is in line with a number of OCD precedents in this using those same figures. Permian's concern, one of Permian's major concerns in their materials is that Avant is not proposing to develop the second Bone Spring shale, which we'll get into in quite a bit of detail. But that argument actually falls flat when we look at the facts here. First, Permian didn't drill second Bone Spring shale wells right next door. The second Bone Spring shale is not going to be stranded, which is one of Permian's main points. Permian is not initially targeting the Avalon or the Wolfcamp, the lower Wolfcamp or the Wolfcamp, the upper Penn. And so Permian's argument that somehow leaving behind reserves in a 0.5 mile stretch is going to be stranding falls flat when you consider that Permian is leaving behind 1.5 miles of 3 different benches. And finally, and I think this is fatal to Permian's applications, none of Permian's second Bone Spring applications actually include a pooled interval that corresponds to their second Bone Spring shale wells. So their second Bone Spring applications do not include a pooled interval that captures the wells upon which they are supporting most of their opposition to Avant's applications. And so those applications may need to be dismissed because they certainly don't support Permian's request here. And Permian hasn't just demonstrated that it's ready to begin to develop this acreage. They've had this acreage since 2023, but Avant has only had this acreage since 2025, and they've undertaken a number of steps to obtain additional working interests. And Permian also, like I said, many of its pooling applications appear to have fatal deficiencies. And it's proposing AFE costs that we'll talk about later that are using an incorrect casing design for this particular area of Lee County. So those costs are inaccurate. And it recently completely changed its surface facilities. It has solutions that it's posing for problems that are overly expensive and likely insufficient. And Permian doesn't seem willing to develop the Avalon, Lower Bone Spring, and Upper Penn in the near term, which, as I mentioned, creates waste and negatively impacts correlative rates. So for these reasons, Avant's application should be granted and Permian's denied.
Thank you. Ms. McLean, do you want to do an opening now, or do you want to do an opening before you present your case in chief?
Now, please.
Go right ahead.
Thank you. Can't let that go without saying something, as you know. As Ms. Bennett stated, we are here about competing development plans. And while Avant seems to believe they win simply because of greater working interest ownership and the fact that they're going to drill more wells, that's simply not the case. PR's working, or Permian Resources working interest is not insignificant. Even going with Yvonne's calculations, we have almost 33% working interest in our 1.5 mile wells, which is not, as I said, insignificant. You will hear a lot of testimony about the way that these calculations have been made. And this is quite novel, I think, before the division to present this type of ownership interest. What's going on in section 23 is that there is an old ability to convert overriding royalty interest into working interest ownership. And this ability to convert can be executed after written notice of the intention to spud wells. And the overriding royalty interest owner who can make the election can make it at that time. So what Permian Resources has done is present what it believes to be the most realistic working interest ownership that will also be in the division's best interest, because we have chosen to pool all potential working interest owners, not just the ones that have currently made a premature election to convert, so that we don't have to come back at a later time and reopen these cases and pool other working interest owners who chose to make the election at a later date. So Permian Resources will present that working interest ownership and those calculations. And Avant has chosen to make those calculations in the rebuttal exhibit. So we will get into that. But even looking at Avant's calculation, Permian Resources still owns a significant interest in these spacing units. Importantly, Permian Resources Development Plan also is not stranding resources. I'm unsure what Ms. Bennett is talking about and us not pooling certain intervals. Permian Resources is seeking to pool the first, second, and third Bone Spring intervals and the Wolfcamp Formation in all of section 23 and the north half of section 26. Avant, it has no application that is seeking to pool the second Bone Spring interval in the north half of section 26. This is important, as you will hear, because there is no other way to develop this second Bone Spring without the 1.5 mile laterals that Permian Resources is going to implement in this spacing unit due to potash drill islands. So if we do not develop and we do not pool the second Bone Spring in the north half of 26, Coterra, who only owns in that acreage, is completely out of luck and can't develop those resources. And the state is too, because as you'll see, this is very, very valuable, the second Bone Spring, and produces a lot of reserves. So if Avant prevails, the second Bone Spring in the north half of section 26 will be stranded with no hope for development. Permian Resources Development Plan, you'll hear, is also more cost efficient and timely due to numerous existing facilities and the offsetting spacing unit, the PAXI unit, which is operated by Permian Resources. And it's directly offsetting with wells, less than 1,000 feet from where the Spicy Chicken unit is. Finally, Permian Resources has made real plans to develop this spacing unit by taking into account H2S. You'll hear a lot about that today. It's an offset of drilling in this area, and particularly in the Avalon. And due to Permian Resources' extensive operations in this area, they know that that's a real possibility and have taken steps to be able to drill and operate wells in the future. They don't intend to do Avalons in their initial set of wells, mostly because they want to account for this significant risk. And H2S, as you'll hear, can lead to significant additional costs associated with drilling, as well as significant safety concerns with drilling wells in that area. Overall, Permian Resources will show that it will be in the best position to develop this acreage. Its ownership interest is not insignificant, as Avant would like you to think, and Permian Resources will best prevent waste and protect correlative rights.
Okay, thank you both. Is there any other thing you want to do before we call your first witness?
Nothing for me. Thank
Go
you.
right ahead.
I'd like to call Tiffany Sarantinos, please.
And Ms. Sarantinos, will you pull that microphone closer to you? I know you have a book there as well. And would you, for the record, tell us what you have in front of you?
I have the binder of our exhibits and PRs that have been labeled and that you guys saw ahead.
And when you say PR, you mean Permian Resources?
Yes, yes.
All right. For the court reporter, if you would avoid using acronyms or abbreviations, at least at first.
Yes.
And then
Best.
go right ahead, Ms. Bennett.
Did you swear the witnesses in? I apologize.
Everyone's sworn in.
Okay, great. May I ask for the ability to share my screen?
By all means.
Tiffany Sarantinos.
Thank you. And what I'm sharing on the screen are Avant's pre-filed exhibits and testimony. Ms. Sarantinos, if you could state your name again and for whom you're employed and for how long you've been employed.
My name is Tiffany Sarantinos. I'm with Avant Operating and I will have been with Avant for 6 years in May.
And you are familiar with the land matters at issue in these cases, right?
Yes.
And did you prepare written testimony?
Yes.
And did you prepare exhibits?
Yes.
And have you had a chance to review your written testimony and exhibits since they were submitted?
Yes.
And are there any changes you'd like to make to your written testimony?
Yes, there's a couple.
Okay, and if you could walk through those one by one, or actually I'll ask you questions so that the record's clear about which ones you want to change.
Perfect.
And then we will just make sure everyone understands what's changing. So the first exhibit that I think that we've discussed that you need to change is the working interest ownership slides that you prepared. Is that right?
That is correct. After filing our exhibits, we have acquired the trainer partners interest, which would increase our working interest and our working interest control across the board of all of the exhibits for all of the cases.
Ms. Sarantinos, before you continue, Ms. Bennett, you have an exhibit on the screen, but I don't know which exhibit it is. Can you, if you're going to bring up an exhibit, if any party wants to bring up it, just say what the exhibit is.
Yes, this is exhibit A4.
A4.
And this is an exhibit of the working interest control that will need to be changed.
A4, thank you.
So Ms. Sarantinos, can you briefly describe what will need to be changed on this exhibit?
So we would increase in the section 23 unit, the unit working interest by 1.74%, I believe. And also the unit working interest control by 1.74% interest.
And just to be clear, this is the slide that shows the working interest for section 23. Is that right?
That's correct. Before the acquisition. Yes.
And then the second page of exhibit 4 would also need to be changed. Is that correct?
That is correct. Yep.
And why would this exhibit need to be changed?
So this one also does not reflect the trainer partners acquisition. And in this one, I believe it increases it by 1.61 or 16% in the working interest and the working interest control.
Thank you. And so, and then you also have exhibits that are unit recapitulations for each unit, right?
That is correct.
And would all of those need to be updated as well to reflect the trainer interest being added?
That is correct. And the working interest control, I think we have on that tab as well. Yeah.
Thank you. The next exhibit that I'm going to bring up is exhibit A11 as an example. Sorry, there's somewhat of a delay between my computer and the screen. Do you recognize this exhibit, Ms. Sarantinos?
The non-standard one? Okay,
Yes, non-standard unit exhibits.
Yes.
And in this exhibit on the notice parties, which I'm turning to, and that's page 89 of 322. That's where it starts. Do you see that?
Yes.
On page 90 of 322, do you see where it says waiver pending for PEXB?
Yes,
And have you received the waiver?
we did. Yes, we received it on the 20th.
Thank you.
Yes.
And then the last change I believe you have is in the discussion of the chronology of contacts,
Yes.
which is, sorry, just finding that. A6,
Yes.
and that's your chronology of contacts with Permian Resources.
Yes.
And
And we
what-
just wanted to add an additional entry that an additional offer was sent over on the 19th. An aggressive offer, actually.
And so you want to update that to show your most recent discussions with Permian.
Correct. Yep. Trying to work a deal up until today.
Thank you.
Mhm.
So with those changes, and we'll make those changes when we resubmit exhibits, do you adopt your testimony and exhibits?
I do.
Thank you. I want to ask you to give a brief summary of your direct testimony. So if you don't mind, and I'll go back to your exhibit A4, recognizing that it's needs to be updated, but this is the information we have in our materials at the moment. So if you wouldn't mind giving a brief summary of the working interest ownership in each of the two different types of units and the working interest control.
Sure. This would be for our 500s. Avant is applying to pool for the Bone Spring. And this shows that we have previously the 513.77. The additional acres are obviously not shown on here. And we have 80% approximately working interest control with additional JOA owners, which increases our working interest control to the 93, which again should be increased by that additional 1%.
And so when you submit the corrected testimony, this will show a working interest control of 94%.
Correct.
And turning to the next page of this exhibit, can you briefly describe the working interest control, or working interest ownership and working interest control on this exhibit?
Yes. So this one shows Avant is applying to pool for a 960 acre spacing unit in the Bone Spring and the Wolf Camp. Again, here you'll see that we have the majority working interest and the working interest control. The working interest control has the 63% approximate prior to the trainer partners with the parties under JOA, which would increase it to approximately 64%.
Thank you. And so in both of these slides, you're showing that Avant has both the majority interest in the units. That's undisputed. Is that right?
That is correct.
And that Avant has the higher working interest control.
The significant higher. Yes.
I'm going to now turn to is there anything else you wanted to say about your direct exam testimony before I turn to your rebuttal exhibits?
I don't think so.
I'm going to stop sharing and turn to the rebuttal exhibits. While I'm pulling this up, one of the things you mentioned that you need to change to your direct testimony is the summary of communications with Permian Resources. In your opinion, has Avant engaged in good faith negotiation with Permian Resources?
Yes, there was extensive negotiations that have been happening since probably over 5 months. Avant feels that we were the ones taking charge of all of the trade talks. We took several trades to PR, none of which they presented any counter trades. We presented an offer at the beginning of April, even after we knew that we were heading to contested hearing. And then again, the second aggressive offer that was given on the 19th.
Thank you. Trey. For some reason, I'm having some issues with sharing today. It does not want to allow me to share. So I'm going to not share for the moment because it's not allowing me to. I don't know if it's the share button is grayed out on my computer. So we'll come back to that in a moment, but you have your rebuttal exhibits in front of you, right?
I do, yes.
Okay. Let's turn to your rebuttal exhibit. Well, first of all, you prepared a self-affirmed declaration in support of your rebuttal exhibits, right?
Correct.
And so let's turn to your rebuttal exhibits. You prepared 4 rebuttal exhibits, is that right?
That is correct.
And can you please explain to the division why you've decided to prepare rebuttal exhibits when you saw Permian's direct testimony?
I think the biggest exhibit was of concern was their working interest. They are purporting working interest that does not exist. It's speculative and can be misleading to the commission. Many assumptions could be made for future assignments or other activities that will change a working interest, but what should be presented to the division is what should be of record today.
And that's what you put in your pre-filed testimony, is that right?
Correct. And we provided the document, yes.
And when you reviewed Permian's testimony, did you see in their testimony the assignment and option to convert to override that Permian's counsel was referring to earlier today?
They did not provide it, but I remember seeing a footnote where they were purporting their working interest, but under it in red, it basically also supported what we believe is that these are assumed working interests or assumptions made on parties that have not made these elections whatsoever.
Thank you. And so is your rebuttal exhibit A1 the assignment and the agreement that is the assignment and option?
That is correct. It's a 1980 assignment of override royalty interest.
And have you had a chance to review that?
Yes.
And does it allow overriding royalty interest owners to exercise an option to convert to a working interest?
Correct.
And are there steps, just in general, are there steps that need to be followed before an option can be exercised?
Yeah, this is not a blanket assignment of working interest or leasehold whatsoever.
And so it's not an automatic assignment or conversion is what you're saying?
Exactly. Yep.
And to your knowledge, has Permian Resources converted its override to a working interest?
To my knowledge, no. And we checked county records before coming here. So.
And have you reviewed Permian Resources rebuttal exhibits, right?
Yes.
And did they provide any documentation in their rebuttal exhibits that they had showed that they'd converted?
No, they just seem to be comparing or restating again their assumptions of parties that will be converting. And we have known verbal that some of those parties do not intend to convert. So it is inaccurate.
Thank you. And then you went, even though those are just assumed numbers and purely hypothetical, you undertook to do an analysis to show, even assuming those numbers, that Avant has the majority interest. Is that right?
That is correct. Yeah.
And what, if you could turn to your rebuttal exhibit A3, and again, I apologize that I'm unable to share, but it's rebuttal exhibit A3. If you could turn to that rebuttal exhibit. Do you see that?
Yep.
And could you please describe to the examiners what rebuttal exhibit A3 is?
This is the potential scenario, which just basically restates that AO2 still holds the majority working interest and majority working interest control, even when using PRs assumed and inaccurate numbers.
And what is Avant's working interest control, even using the assumed conversion?
In the section 23, 640 acre unit, it is 85.54. This includes our working interest control with JOA owners, Chief, Trainer, TD, and Diaga. And PRs increases to 10.56 because we also recognize their acquisition of WR non-op.
And I'm able to share my screen now. So is this the exhibit A3 that you were just referring to?
That is correct. Yes.
And this is, again, this assumes the conversion has taken place.
That is all parties convert, yes, which we also know is still not accurate because we know that there are parties on this list who do not intend to convert.
And again, even with assuming all parties convert, Avant has 85%.
Yes, a significant working interest, yeah, control.
And then turning to rebuttal exhibit A4, are you seeing that on the screen?
Yes,
Is this your rebuttal exhibit that addresses the 1.5 mile laterals?
that is correct. Yep, this is for the 960 acre unit using the same, what we believe to be incorrect assumptions. And this is all parties converting. And you'll see that Avant still holds the majority working interest control here with almost 58% compared to their 38%.
Thank you. Now on this one, it shows Diaga on both of these slides. Is that right?
Yes, that is correct.
And you saw in Permian's rebuttal exhibits that they have a letter of support from Diaga and that Diaga has signed Permian's JOA. Is that right?
I did. Yep, I saw it.
And so can you explain to the examiners why you included Diaga in your summary of working interest control attributable to Avant?
Yes, we felt it was correct to leave Diaga in our working interest control, and also I'm sure they believe the same because they have signed our JOA. They have expressed their interest to participate in our unit under the JOA. They also did not oppose our development plan, even in the letter of support that they provided to Permian. It just says that they support them, but it wasn't in opposition of Avant. And additionally, they did not send us any additional communication that they did no longer wanted to be under our JOA.
And so that's why you're including them in your ownership control category.
Correct. And even if we were to remove that, it's such a small interest that it really doesn't move the needle much. It's 0.2%.
And this, sorry, I apologize. Yeah. This reflects the update to include the trainer pending acquisition. Is that right?
That is correct. Yes.
And and by this I mean exhibit A4 includes Petrolux as one of the interests that you're including as committed to Avant. Do you see that?
I do.
And did you see in Permian's materials that they are asserting that Petrolux does not own an interest in the north half of section 26?
I did, yes.
And can you explain to the hearing examiners why you've included Petrolux in your exhibit and consider them to be under your control?
Yes. So with the Petrolux entity, it actually was never released. There is no county records and no BLM filing records that moves any interest out of Petrolux. If I would had to have backed into PR removing them, it would have to be based on, again, additional assumptions that are not placed of record. I believe they ran it forward from Monarch, which is a stranger in title.
And so it's your understanding or Avant's understanding that Petrolux does own in the north half of section 26?
Correct.
And that's why you've included them in the unit recaps?
Correct.
Earlier, in your tract maps, you did not propose to pool Citadel or Blue Star, is that right?
That is correct. We did not pool them as working interest owners. We have pooled them as their interest is today, which is of record, and they're overriding royalty interest owners.
So in your opinion, the pooling notice that you sent out and the parties that you intend to pool or seek to pool are appropriate given the current state of title?
That is correct. And I would make the assumption that if they wanted to participate at a later time, that they would obviously most likely want to be under our JOA because we've had them under several JOAs before as well. So they would have that option and right to do so later.
Thank you. Is there anything else you wanted to add before I turn you over for cross-examination?
I don't think so.
Okay, thank you very much.
Thank you.
Ms. McLean?
Yeah, and I'll probably share my screen too.
Please. And when you're sharing your screen, would you tell the court reporter which exhibit you're bringing up?
Yes, sir.
Thank you.
Okay. Good morning.
Good morning.
Let's go. I'm on Avant's rebuttal exhibit A. Paragraph 11 of your testimony. Oh, sorry, you're sharing the wrong screen. Sorry, we're on your regular exhibit A.
Okay.
A2, your direct self-affirmed statement at paragraph 11, where you say that each party is proposing units that include section 23 and the north half of section 26, and also proposing units that include only section 23, correct?
Correct.
But Avant isn't proposing any units that include the second bone spring in the north half of section 26, is that correct?
Correct.
And
Objection. That is not what is reflected in the testimony.
Okay. To help me out,
Mhm.
what are you saying is reflected in the testimony?
Avant is proposing to develop the north half of section 26 in the second Bone Spring sand, not the second Bone Spring shale. So that was a vague question in asking whether Avant is proposing to develop the second Bone Spring.
Ms. McLean, do you think that the question could be asked differently, or do you oppose the objection?
I oppose the objection because I think it's clear from their application that they are not seeking to pull any second bone spring wells in the north half of section 26. And it expressly says so in one of their applications, which I could point out for the division.
Yeah, my apologies. I was.
Would you withdraw
Yes,
the objection?
yes, I do. Yeah, I was misunderstood.
Did you answer
Yeah.
the question? Sarah?
I did. Yep.
What did you answer? I didn't hear it.
We did not.
Sorry?
No.
Looked at her.
Yeah.
Do you want me to re-ask the question at this
Just
point?
because now that makes me more confused. Your answer is making me.
Go
Did you ask the question again?
Yes, I will. Thank you. Avant isn't proposing any units that include, sorry, I already asked it. This is.
Go ahead.
I was second guessing myself on reading it for a moment. So Avant isn't proposing any spacing units that include the second bone spring and the north half of section 26, correct?
Correct.
And Permian Resources does have 1.5 mile laterals that extend into the second bone spring and the north half of section 26, correct?
Correct.
And Avant doesn't own anything in the second bone spring in the north half of section 26, correct?
Neither does PR. Correct.
I didn't ask you that. I saw you wink at me. That's cute. But my question was, Avant doesn't own anything in the second bone spring in the north half of section 26, correct?
Correct. It's owned 100% by Katerra.
Who is here today supporting Permian Resources application, correct?
I believe that's what he said. Yeah, and did not oppose ours.
Speak more.
I believe that's what he said, and he said he did not oppose Avant's.
But Coterra said that they support Permian Resources in the development because they think they will best develop this acreage, correct?
He might have said that, yes.
Okay. And so at this time, Avant hasn't included any working interest calculations that include interest owned in the second bone spring and the north half of section 26, correct?
Correct.
Let's go to paragraph 16 of your testimony. Right here.
Yes.
For the competing cases covering section 23 and the north half of section 26, AO2 has 62.88% working interest control and 53.52 working interest, and Permian owns 32.99%, correct?
This is without the additional trainer interest, but yes.
Okay, and Trainer is one of those parties that has that ability to convert from an override.
An additional interest could be.
Oh, can you let me
Yes.
finish answering my question before you start, or asking my question before you start answering?
Sure.
Thank you. Trainer is one of those parties that has the ability to convert an overriding royalty interest to a working interest, correct?
Yes, a portion of his interest can be converted.
Okay, thank you. And TD Minerals, who Avant also has listed as a working interest owner, has actually made that conversion
Correct.
Let's go to Avant Exhibit A9. And we'll go to the second page of that, and that's page 84 of their exhibit packet. And so TD Minerals here is listed, oh, sorry, let me move this. TD Minerals, right here is shown as 3.17% in the tracked working interest ownership, correct?
Correct.
And that working interest percentage is the working interest they get after making the election from the override to the working interest ownership?
No, these are all record title interests. So this is their purported or their correct working interest as of today.
But they did have the ability to convert from an override to a working interest owner.
Yes.
Correct? And they made that election to convert, correct? And so does this take that into account, the election to convert?
Yes, it displays their current record title interest.
So that would be their initial working interest plus the additional working interest they gained as a result of converting from the override to the working interest owner, correct?
Assumably, yes.
And you actually have Permian Resources listed on Exhibit A9 twice, correct? Or
Yeah.
Earthstone, who is the working interest owner here.
Yes.
And why do you list them twice?
Sorry, so you're referring to like the tract 1 and then the tract 2 interest? Because they own differing working interests within those tracts.
And so if you add up their total interest ownership here, it's over 33%, is that correct?
Yeah, approximately. Yep.
And I think you said in your direct testimony that the division should only consider what is of record today, correct?
Correct.
Let's look at your rebuttal exhibit that you mentioned, this assignment of overriding royalty interest and options. And this is of record, correct?
This document?
Yes. Yes. And so the ability of an overriding royalty interest owner to convert to the working interest is quote of record, as you would term it.
No, I would disagree with that. This is an assignment of an override, which has been documented. The option to convert is an action that has to be taken.
But that option is not of record?
No, I would say no. This is an assignment of an overriding. This is not a leasehold assignment.
So at your rebuttal exhibit A2, and this is like a shrunken version of what's of record, right?
Yes.
You call out that this person is granted the option of converting their overriding royalty interest to a working interest, correct?
Yes.
Okay. I'd also like to go to what's been marked as, and this one is Permian Resources Rebuttal Exhibit A13, which Avant did not stipulate to the admission of. So I would like to attempt to use it on rebuttal and enter it that way. I don't know what the division would prefer.
You're talking about C5 now?
I'm talking about, it's there are exhibit C13, A13, which Avant did not stipulate to. And it's a side-by-side comparison of working interest ownership.
And you'd like to use it now for demonstrative purposes?
I can use it for demonstrative. That's fine.
That way we don't have to worry about admitting it. Okay, so to be clear, for the court reporter, this exhibit's A13, you said?
A13, yes.
A13, which is not admitted evidence, is going to be used for demonstrative purposes only. Is there an objection to that, Ms. Bennett?
Not to use as a demonstrative. I will say it's cumulative and duplicative of the materials in the record already, previewing.
You can do redirect, of course.
Yes, of course.
Based on it as well, without admitting it, but I'll allow it as demonstrative.
Thank you. Okay, this is Permian Resources Exhibit A13. And have you reviewed this?
Yes.
Let's see if I can make it a little bit bigger.
Yeah. Thank you.
Too big. All right. Okay, and so on these tables, Permian Resources lists all the working interest owners, including those that have the ability to convert from the override to a working interest owner, correct?
Yes.
And then you see in table 2, the Permian Resources working interest calculations. It has additional interest owners of the Siddle and Blue Star royalty, correct?
Correct.
And they have the ability to convert their overriding royalty interest into a working interest, correct?
They have the option, yes.
And you did not include them as potential working interest parties to be pooled, correct?
Correct. We pulled them as an overriding royalty.
Right, and not working interest, correct?
Correct.
Let's go back to Avance Exhibit A13. And it's page 101 of Avant's full exhibit packet. And this shows Avant's second Bone Spring development, correct?
Yes.
And the only second Bone Spring development that Avant has is 1 mile laterals in section 23, correct?
Yes.
And you don't account for Permian Resources' ability to convert their overriding royalty interest to a working interest in this table, do you?
No, we displayed the working interest of record in these.
Okay. And Avant doesn't have any second Bone Spring wells in this exhibit that include the north half of section 26. Is that correct?
Correct.
So your working interest breakdown here for these second Bone Spring wells, but Bone Spring wells wouldn't include Coterra because they only own in the north half of section 26, correct?
Correct.
And at this point, Avant has no plans to develop the second Bone Spring in the north half of 26. Is that correct?
I would actually defer to one of my reservoir engineers or geologists.
Well, you have no applications that have included that acreage. Is that correct?
I would let them plant or speak on potential future development.
No, I'm asking currently before the division. Do you have any applications that include
No,
the
correct.
second Bone Spring in the north half of
We do
section
not.
26? Okay, thank you. No more questions.
Thank you. Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. Saratinos, can you please briefly describe for me the depth severances that is within the proposed units?
I would like to defer all of those to our ops technical team as well, if I may.
Is it not, are the depth severances not referenced within your self-affirmed statement?
I do not believe so, no.
Do you not, were you not involved in are you aware of which depths Avant wishes the division to force pull in each case?
Generally speaking, yes.
Do you believe it's Avant's intention for the division to force pull the entirety of the Bone Spring split up by the depth severances?
Excluding the second bone, yes.
Excluding the second bone, can you clarify what you mean by that?
Excluding the depth severances that we listed in our Bone Springs applications.
Oh, I see. So when you said excluding the Bone Spring 2, you were implying that that's the break between the Bone Spring 1 and the Bone Spring 3. Is that all you were referring to?
Yes, that's correct.
Do you know if Avant would like the division to force pull the second Bone Spring carbonate?
I do not believe so. I think they have been pooled by Katerra previously.
Don't have a page reference here. Do you know for sure where your self-affirmed statement is occurring within the exhibit packet?
Mr. McClure, I can help with that, and then I can pull it up on the screen in just a second, but her self-affirmed statement starts at page 40 of 122. I'm sorry, of 322.
Thank you, Ms. Bennett.
And I have it pulled up here on the screen if that's helpful.
Yeah, I'm also looking at it on my monitor here. Okay, Ms. Saratinos, I'm looking at page 46, where you start talking about case number 25829, paragraph 46. Looks like it's the start of that section. Oh yeah, it looks like Ms.
Yes.
Bennett has it pulled up.
Yes.
Do you see paragraph 47, where it seems that Avant is asking to force pull the entirety of the second bone spring? You see the sentence I'm referring to?
Yes.
Do you think that, do you think that's accurate or not?
I'm not sure.
Okay, so is it possible that maybe what you meant was second bone spring sand?
Yes.
Okay. And which of Avant's later expert witnesses would be able to best speak upon, I guess, what Avant's intent is here?
He put his hand in front of his mouth. This is court reporter. Can you repeat your question, please? You put your hand in front of your mouth, and then I heard bumping.
Yes, ma'am. Ms. Saratinos, which of Avant's later expert witnesses would best be able to address Avant's intended proposed unit here?
I'll let them decide, but I assume they both are prepared.
Okay. And is it your belief that, or which of Avant's later expert witnesses would be best able to speak on the depth severances within the
Probably
proposed units?
our geologist, John Harper.
Okay. Okay, I'm looking at, your breakout of interest. Let's see, the first one's on page 84, looks like. To be fair, I don't know if we need the aid, but I'm looking specifically at the Petrolux incorporate it. Can you provide a little bit more detail as to what you mean when you say under contract?
Yeah, we will be acquiring this interest.
Okay, but when you say it's under contract, is it currently under contract, and what are the
It is-
terms of those?
That's correct.
Okay.
It is currently under contract with plans to close probably within the next week or so.
Well, plans to close within the next week or so. So when you say it's under contract, what do you actually mean by that, I guess?
I mean, we have no reason to believe this will not be closing. We've been working with these parties for a very long time.
Okay, but as of right now, what is currently executed?
We have a letter agreement with them. It's just the diligence period that is running right now.
Okay, so then you have a signed letter of agreement from this entity that states what?
Confidential information, but that we intend to close for a set dollar amount.
Okay, so essentially they've signed an agreement, and I'm not worried about the details, other than this agreement states that they intend to sell their interest to Avant. Is that correct?
That is correct.
And do they have the ability to back out of that deal?
I would have to revisit the contract, but I do not believe so, no.
Well, I guess regardless of that, is it accurate to say that this entity was provided notice of this application?
Yes, that is correct.
In regards to the difference in interest between Avant and Permium, is the entirety of that difference attributable to this conversion between overriding royalty interest owners to working interest?
It is not, no.
And I believe you spoke on it a little bit earlier, but can you give me another brief summary as to the other divergence, I guess, beyond the overriding royalty interest conversion?
Could I peek at that, our cheat sheet?
I think what he's asking you is just to, I'm not trying to, may I
Go ahead.
assist the witness a little? I think what he's asking you, Ms. Sarantinos, is to run through your working interest recap to explain the difference in current title as between Avant and Permian in terms of the interest that you have under your control.
Okay.
Is that correct, Mr. McClure?
I mean, I believe so. Essentially, I was asking for, well, let me restate my question, and maybe Miss Bennett's might be more easier there for the expert witness to understand. But essentially what my question was is I asked if all of the differences in what Permian believes the working interest to be and what Avant believes the working interest to be, if that can entirely be attributable to these override conversions. Your response had been no, it cannot, or it does not address all of the differences. My follow-up question is, what are the differences that are not explained by the conversion of overriding royalty interest to working interest?
Let me ask the witness. Do you understand the question now?
Not fully, no.
Mr. McClure, it's not clear to the witness. I think I understand it, but I think Do you remember the question where you answered no to just a little while ago? Where he asked you about how it's attributable and you said, no, it's not attributable to that factor?
Mm-hmm.
You do remember that?
Yes.
Okay. And you answered, and what did you mean when you said no? Let me hear your answer.
I thought he was asking, is our interest differential only attributable to the override document? And it is not. We still have a substantially higher working interest without any of those conversion scenarios.
So, Mr. McClure, were you talking about the interest differential or something else?
I'm talking about the interest differential.
Okay, then, okay, you have the answer now. So why don't you ask a follow-up to what she just said?
Well, my follow-up, I guess, it's kind of my original question, I guess, is Ms. Saratinos, you said that there is an additional change, an additional difference in what Avant believes its interest to be. What are you
Yes.
referring to?
Just our acquisition of the Trainer Partners Ltd, which just increases our interest in the, I think we're looking at the 960 unit by the additional 1.16% working interest.
Okay, so other than the acquisition of Trainer Partners Ltd and consideration of conversion of overriding royalty interest owners to working interest owners, is there any other differences between what Avant believes the interest to be and what Permian believes the interest to be?
I think our only difference in title per se is the Petrolux entity, which is the 8 acres, which is still not very substantial. It's less than 1% difference.
And I'll ask them this, but do you know who they believe that those 8 acres to be attributed to?
Yes, they believe it ends up with Earthstone Permian.
So then their interest is what you're saying, is that correct?
That is what they are saying, correct.
Okay. Okay, just a few pages down, page 86. And this slide seems to be, this is talking about your non-standard spacing unit, your NSP application. Do you see where I'm referring to, Ms. Saratinos?
Yes.
In your depiction on the right-hand side of this screen, is there a reason that you're depicting 2 separate spacing units, or is this simply a typo?
It must be a typo because I think those are the approved CTBs that we have plans for.
Okay, so it is accurate that, to your understanding, it is accurate that Avana tends to have 2 central tank batteries, though. Is that correct?
I believe so, but I will defer that to Reservoir. But yes.
Okay. So then of the typo here, potentially the only typo would be the HSU. It should depict a singular HSU rather than 2 of them. Is that correct?
Of the units. The unit, the 2 separate units into one.
Yes. Is it accurate to say that it should only depict a singular non-standard spacing unit on the right-hand depiction?
Yes. Yes.
Okay. Within any of your direct exhibits here, do you include a breakout of the costs associated with all proposed facilities and wells?
I did not know.
Oh, excuse me. I guess that would be your one of the later experts. I apologize. Yeah,
That's
that
okay.
wouldn't be in your exhibits regardless. Earlier, you referenced that Avant has received written waiver from PEXP. Is that correct?
BEXP? Yes, that's correct.
And is that in regards to all of the cases?
Yes, yes. I believe we listed them all in the waiver notice.
Yeah, very good. Mr. Hearing Examiner. Actually, let me make sure on my notes. Yeah, thank you, Miss Saratinos. Mr. Hearing Examiner, at this point, I don't have any more questions for this expert witness.
Thank you, Mr. McClure. Before we go to any redirect, let's take a 5-minute break.
Okay.
Thank you very
Thank you.
much. We're off the record.
Speak softly. Come on, I don't sorry. No, I'm so sorry. Speak loud. Want to hear what you have to say.
Mr. Hearing Examiner, when we do come
Yes.
back, I do have one more question for Ms.
Okay,
Saratinos
sounds
that
good.
we may want to address.
All right, it's 10:34 a.m. We're back on the record and whoops. But we were back on.
Yes.
Should we get back on the record? All right, 10:34 a.m. And Mr. McClure has another question for Ms. Saratinos.
Thank you, Mr. Hearing Examiner. Ms. Saratinos, is it accurate to say that originally Avant was asking for a 800 series of wells to be dedicated to the proposed Wolf Camp unit?
Yes, that is correct.
Is it also accurate to say that Avant now wishes to no longer request those wells to be dedicated to the proposed Wolf Camp unit?
We do intend to apply for them, but we were just correcting one from a previous case 2 weeks prior, where we know it needed to have a correct pool code. So instead of having to address that issue here, we thought it would be in the division's best interest to reapply with the appropriate pool code. But our intent is still to develop those 800s.
Now, when you reference the appropriate pool code, do you mean to imply that Avant will be requesting a forced pooling case in the Cisco and Canyon formations?
I believe that is the correct one, yes.
Okay, but for these cases that we're hearing today, is it accurate to say that Avant is no longer requesting those 800 series wells?
Yes, that's correct.
Okay, thank you, Ms. Saratinos. Mr. Hearing Examiner, I now no longer have any more questions.
Thank you,
for
Mr.
this
McClure.
expert
Ms. Bennett?
witness.
I just had one really brief redirect. Ms. Saratinos, do you recall being asked by Mr. McClure about the depth severances in the Avant applications?
Yes.
And you're generally familiar with the depth severances in the applications, is that right?
Yes, that's correct.
Did you, and you deferred to Mr. Harper and Mr. Kelly to talk about those more later?
Yes, correct.
And is that because the Avant team worked on defining the depth severances together?
Yes, that's correct.
Thank you.
Is there any recross on that one answer?
No.
Mr. McClure?
Mr. Hearing Examiner, maybe just one follow-up on that.
Ask as many as you like.
Thank you, Mr. Hearing Examiner. Ms. Saratinos, is it still accurate that Mr. Harper would be able to provide a more detailed response as to Avant's intent and for those depth severances?
Yes, that's correct.
Okay, so do you have anything further from your review to add on that topic of depth severance?
I do not.
Okay, thank you, Ms. Saratinos. Thank you, Mr. Hearing Examiner.
All right, thank you. May this witness be excused?
Yes, thank you.
Thank you. Okay. And Ms. Bennett, through this witness, all of the A exhibits, including the rebuttal exhibits, have been entered.
Yes,
I thought they had.
thank you.
And you have some corrections to make.
Yes, we do.
And you've written them all down. You
I
have a
have.
record of those.
I do.
Sounds good. We'll deal with that at the end of the hearing. Do you want to call your second witness?
Yes, I'd like to call John Kelly. I'm sorry, John Harper.
That's right. That's right. Thank you.
Good morning, Mr. Harper. If you would please say your name for the record.
John Harper,
And by whom are you employed?
Avant Operating.
And how long have you worked for Avant Operating?
Since inception of Avant Operating, so almost 7 years this October.
And what is your title at Avant Operating?
Senior Vice President of Assets and Exploration.
And you prepared testimony and exhibits for the hearing today, did you not?
I did.
And are there any changes you need to make to your testimony?
No.
And do you adopt your testimony and exhibits?
Yes.
I'd like to ask you to give a brief summary of your direct testimony. So if you could give a brief summary of the geology in the area.
Yes, I mean, this shows our plan within Lee County, New Mexico, showing the development plan of the Avalon, the first Bone Spring sand, the second Bone Spring sand, the third Bone Spring sand, the upper Wolfcamp and lower Wolfcamp. And as Ms. Arantinas just discussed, we plan on refiling the 800 series Cisco Canyon wells later.
What are you showing now?
I'm getting ready to show his an exhibit, but I'm not quite there yet. I'm just getting lined up. And did you prepare a slide that shows an overview of the competing cases?
Yes.
And is that your slide? Right there. Okay. Is that your slide B4?
Yes.
And is this a summary of what you just stated about the different targets that Avant is seeking to pool?
That is correct. It shows our development plan of the Avalon, the first Bone Spring sand, the second Bone Spring sand, the third Bone Spring sand, upper Wolfcamp and lower Wolfcamp versus Parent Resources exclusion of the Avalon, only 4 wells in the first Bone Spring sand, a mixture of second Bone Spring U-turns and shales, and then various third Bone Spring sand, upper Wolfcamp, and no lower Wolfcamp development.
And just really quickly on your geology slides that we went through a moment ago, very briefly, do you, is it your understanding or based on your opinion that all of the targets that you're seeking to pool in these benches are prospective?
Yes.
And here, what I'm pointing to here is the Permian Resources proposed 201H well. Do you see that? Or upper Wolfcamp development, do you see that?
Yes,
And do you see how the 201H well is depicted at a slant?
I do.
And why did you depict it that way?
Based on their proposals, that's how they defined their bottom hole location, stopping in lot C and stopping short of the full 1.5 mile unit. So I just made it how they depicted it.
Thank you. In earlier today, or is it your opinion that Permian has properly pooled the second Bone Spring interval in its applications?
No.
And I'm going to turn to an exhibit that I think might help us talk through this, which is your exhibit B8. Are you seeing that exhibit?
Yes.
So, and this is an exhibit you prepared, right?
Yes.
And is it an exhibit that shows the Hanson State well?
Yes.
And why is the Hanson State well relevant to our discussion that we're about to have?
It's a type well that's in close proximity, but it's also the exact well that Permian Resources used in their proposals and polling applications to define their intervals of interest.
And do you?
Intervals of interest.
Can you pull the microphone closer to you?
Sure. Sorry.
Thank you.
Do you recall, have you reviewed Permian's second Bone Spring application?
Yes.
applications. And do you recall that in their second Bone Spring applications, they're seeking to pool from approximately, and I should have had it right here in front of me, but I don't, but from approximately 94, 44 and below?
Yes, I believe that's correct.
And so just to orient ourselves, this is a log of the Hanson. And you've shown here the first Bone Spring. And then down below, you start the second Bone Spring sand.
That's correct.
Approximately where on this cross section would the top of the second Bone Spring shale be?
Using the Hanson well that they referenced in their applications, the depth marks are 100-foot intervals. So I would say approximately 92 or 91, 90 feet TBD using Hanson well. That correlates to the Snotty well at roughly 92.25 is the top of the second Bone Spring shale, also known as the second Bone Spring carbonate.
And so in your opinion, the top of the second Bone Spring shale is at approximately 92, 91, 90?
Correct.
And the second Bone Spring shale wells that Permian is seeking authority from the division to pool are at what depths? Do you recall approximately?
Using the Hanson well right there, I believe approximately 93-ish or 92.50. I don't remember the exact depth, but within the second Bone Spring shale interval.
So if I can look back, but I recall it's at 93.30. Does that sound about
Yeah,
right?
that sounds about right.
So in your opinion, is 93.30 within the interval that Permian is seeking to pool for its second Bone Spring sand, or second Bone Spring wells, which starts at 94.44?
I would disagree with that. Their 140, their second Bone Spring shale wells are well above the second Bone Spring interval as they defined it.
And so their second Bone Spring application does not include the second Bone Spring wells.
That is correct.
And those wells, in fact, are those wells in the first Bone Spring then?
As they've defined it, which I believe is incorrect.
And I'm just going to look at one of their applications real fast. Actually, I'm looking at Mr. Paddock's direct testimony. And he says in his direct testimony that the first Bone Spring applications will be from the top of the Bone Spring to the base of the first Bone Spring interval at approximately 94.44. And in your opinion, is the base of the Bone Spring interval at 94.44?
Mr. Examiner, I have an objection to this line of questioning.
Let's hear it.
It's that this issue could and should have been addressed in Mr. Harper's direct testimony, and it was not. So this is unfair surprise. He had an opportunity to address that, and that this has not been done. This is the first time we're hearing about any of this.
So the concept of X should have been part of his direct. What is X?
This apparent argument that Permian Resources' second Bone Spring applications don't include the correct depths for the second Bone Spring.
Okay, and why should that have been in? I'm trying to understand the objection fully before I go to Ms. Bennett. And why should that have been in his direct?
Because Avant has had the depths of the wells since they received the well proposals, and they're included in Permian's applications. And so this would have been a topic appropriately addressed in direct testimony to which we could respond. It's also not included in the rebuttal testimony. This is completely new.
I see. It's not in the rebuttal testimony either.
Right.
Okay, Ms. Bennett?
Thank you. First, Avant did not have the opportunity to put this in their direct testimony. This became apparent to Avant after we submitted the direct testimony. And so it's not something that was intentionally left out of our direct testimony. It was upon review of Permian's exhibits that Avant realized the error in Permian's applications. In fact, we have an exhibit in our direct testimony that is in line with what Avant thought the Permian plan was. So it wasn't as if we were trying to not put this in the direct testimony. In fact, during the direct testimony, we thought the plan was what I think Permian thinks the plan was.
And before you go on, you said you have an exhibit that shows what you were thinking before you got their exhibits. And what exhibit is that?
It's a reservoir engineering exhibit. I'll have to find it.
I think the reservoir engineer is here for Avant. Do you want to just tell her what exhibit that would be?
It's exhibit, sorry. It's page 288 of 322.
Perfect. Thank you. Let me know when you have it, Miss Bennett.
It's right here.
This is it.
No, it's,
Oh, sorry.
No,
Right here. Sorry, it just took a second to catch up.
yes, that's correct.
this is the proper one. This is it. What exhibit number is this?
C3.
I'm sorry, what?
C3.
C3.
Yes.
And that's been admitted into evidence.
It has been.
All right. So show me where on here this shows that you originally thought that, well, what you said before.
Right. So I believe it's the, these wells right here, do you see those upper?
I don't see anything is too small. Can you make it a little bigger?
Sure. Okay, so do you see this 141H well?
Not yet.
My screen is just really slow today. Now are you seeing the 141? I'm trying to circle it with my mouse.
I do see it here, but what does it say over there on the left side in second Bone Spring?
Yes.
Okay, I see it here now, 141H that says. Okay, go ahead.
So this is the plan that Avant thought was being proposed by, and to be fair, this Permian is seeking to target the second Bone Spring shale. That's not the question. The question is whether their applications are legally sufficient, because they do not, the second Bone Spring shale application or the second Bone Spring application does not include these depths. And in terms of unfair surprise, this is not an issue that it's Avant's burden to prove that PR's applications are incorrect. It's not Avant's duty to alert Permian to that. In fact, Permian has been repeating this same error since 2023, I think, when they first filed their applications before the division. So there's no reason that Avant would have had any knowledge that Permian was using the wrong depths until we started looking into it. And
so this is your exhibit.
It is.
So this shows that you were thinking that the 141H and the 143H were in the second Bone Spring.
yes,
Okay. And then what exhibit that Permian filed tipped you off to that the depths are not correct?
I'm not certain if it was a particular exhibit, but more that once Avant received Permian's exhibits, it started really distilling and drilling down into the materials. And that's when it realized that the depths that Permian was seeking to pool do not correlate with the depths of the wells that Permian is proposing in the applications.
Now, the allegation in the objection was that Avant has had the depths that Permian was attributing to the second Bone Spring in their well proposals, and this would have been, of course, many months ago. What's your response to that?
The well proposals do not include the same level of detail as the applications or the exhibits. The well proposals, in fact, just say 9330 second Bone Spring. They don't, as far as I recall, the well proposals don't discuss the depth severance at all. So the well proposals themselves, which is what Avant was using to build this slide off of, would not have identified any error in the pooling interval.
Miss Hardy, did you have any follow-up to that?
Yes, then I think they should have included it in rebuttal because they had this information by the time we.
And,
submit a
and
rebuttal.
Ms. Bennett, why is this just coming to light now? And why was this not in your rebuttal, case?
Mr. Examiner, again, Avant does not need to identify legal deficiencies in its rebuttal case. These are deficiencies. This is akin to subject matter jurisdiction of the division. This could be raised at any time. The division itself could find that this is a material deficiency in Permian's applications. So whether Avant raised it in its rebuttal or today is irrelevant. It's a material deficiency in Permian's applications, and the division, there's no need for Avant to have raised it in its rebuttal testimony.
Ms. Hardy, I'm going to ask for one last follow-up from you before I go offline for a minute and talk to Mr. McClure about what he thinks. But your response to this, to the similarity of subject matter jurisdiction that never goes away, basically.
Well, I don't think it's similar to subject matter jurisdiction because I think it's an alleged leak. They're claiming it's a legal deficiency that they could raise in legal briefing. But I don't think it's akin to subject matter jurisdiction.
Okay. All right, let's take a 5-minute break. We'll be back. Thank you. We're off the record. Good.
Sit down.
You're ready. Oh, you are ready.
That's right.
All right, we're back on the record. It's 11:07 a.m. And Mr. McClure and I discussed the issue. My ruling is that this is not unfair surprise, so I'm going to overrule the objection and I'll explain why. This is an error in I won't call it the application, I'll call it the exhibits, or I'll call it the CPAC. This is an error in the CPAC, and it's not the sort of evidentiary issue that I believe Permian would want to call another witness to rebut in some way. If Ms. Hardy does want to do that, she can explain herself and I'll give her wide latitude. Since this was a surprise to you, I understand that it was a surprise to you. I just don't see how you would have dealt with it with more evidence. It's an error on this document. It can be amended as far as I understand. Maybe I'm wrong about that. I don't know. But I don't find it unfair surprise to point out an error in your document. So, did you ask your question and did you get an answer?
I did, but I would like to make a clarifying remark to your ruling if possible.
No, I prefer not to. Thank you for asking. But I remember you asked a question and the objection came. So I don't believe your witness answered your question. So would you ask it again?
I will. And I will do my best to remember what my question was. In your opinion, is Permian Resources seeking to pool the appropriate interval to capture the second Bone Spring shale in its second Bone Spring application?
No.
And you understand that their applications, in fact, identify the depth severance, right?
Correct.
Okay, so it's not just an issue with the CPAC, which you may not know what that is. Okay. And so if I turn to their applications, which I have one pulled up here. Am I sharing my screen? I'm not, am I? Let me share my screen real fast. Are you seeing this application in case 25833?
Yes.
And do you see that this is an application for the second Bone Spring interval?
Yes.
And is this an application for one of the spicy chicken second Bone Spring shale wells?
Yes, they're 143.
And just turning the page here, do you see this paragraph 5?
Yes.
Does it say due to a depth severance in the Bone Spring formation, applicant seeks to pool interest in the Bone Spring interval only from approximately 944 TBD to 9930 TBD as shown on the Hansen State #1 well log?
Yes, at the second Bone Spring interval only from the 9444 TBD to 9930 TBD from the Hansen State well log. Yes.
And in your opinion, does the 143 H well, which is the subject of this application, fall within 944 TBD to 9930 TBD?
It does not.
And is that true for the remaining second Bone Spring shale application, the 141?
Yes.
In your opinion, does this same issue permeate the first Bone Spring applications, Permian's first Bone Spring applications?
Yes, the 141, the 143 fall within their first Bone Spring interval.
And let me see if I can find one of those applications real fast so we can look at it in black and white. Okay, so here is the application for case number 25838. Do you see that?
Yes.
And this is an application for the First Bone Spring interval, right?
Yes,
And here it has another snippet in the application itself about the depth severance, right? Doesn't it?
yes, it does.
And I'm paraphrasing here, but it says that the depth severance is from the top of the bones, from the top of the bone spring to the base of the bone spring interval at approximately 94.44 TBD. Do you see that?
I do.
In your opinion, is the base of the bone spring base of the first bone spring, excuse me, at 94.44 TBD?
I would disagree with that.
And is this interval here that's being described in paragraph 4, is that the interval in which Permian is proposing to pool to actually drill the 141 and 143 H wells?
Correct. Their second Bone Spring shale, as they've defined it, are planned to be within the first Bone Spring sand or first Bone Spring interval as they've defined it,
And how do you know that?
based on the TBD that they provided in their
And-
application.
And that's because the TBD for the second Bone Spring shale wells, the 141 and 143 is at 93.30 approximately.
Correct.
And 93.30 would be between the base of the first Bone Spring. The top of the first Bone Spring to the base of the first Bone Spring,
Correct.
as they've defined it.
Yes.
And so the same issue permeates their first Bone Spring applications.
Correct.
And have you undertaken to review their third Bone Spring applications?
I have.
And in your opinion, does this issue also present itself in their third Bone Spring applications?
I would disagree with their third Bone Spring applications as well.
And that's because, in your opinion, they do not accurately reflect the pooled interval. Is that correct?
Correct.
Thank you. I'd like to now turn to your rebuttal exhibits. And let me just get here. Do you prepare rebuttal exhibits for these cases?
I did.
And did you prepare a self-affirmed statement in support of your rebuttal exhibits?
Yes.
And is that rebuttal exhibit C?
Yes.
Okay, let's talk about your first rebuttal exhibit, which is rebuttal exhibit number 1. So you reviewed their testimony and exhibits.
Yes, I did.
And what about their testimony and exhibits led you to prepare this rebuttal exhibit C1, which is entitled Avalon is being actively developed all around the AO2 spicy chicken unit?
One of their exhibits in their direct stated that operators do not find the Avalon prospective in this area due to reservoir degradation. I would disagree with that statement. I think based on my research, 5 other operators within a 6-mile radius would also disagree with that statement, given by the 36 active producing ducts or permits all around the spicy chicken unit, and particularly directly above and directly below the spicy chicken unit itself. So I wholeheartedly disagree with their examination of the Avalon being not prospective. And I think a lot of other operators would also agree with that.
Thank you. Another comment that you made on this slide is about the Avant subsurface team and your experience with the Avalon. Did you want to provide some more information on that?
Sure. Permian Resources team went into grave detail about the H2S concerns, and I think sure it's probably a concern to them. It's not a concern to us. The Avant subsurface team has been developing and delineating the Avalon formation almost for 10 years now at EOG Resources and Centennial Resources, which is now Permian Resources. Myself and another Shane Kelly, who's here today, has been drilling the Avalon further and further north in Lee County, New Mexico. We've drilled one of the furthest northern Lee County Avalon wells to date. PR did us the pleasure of calling it out here in their exhibit. The screenshot to the bottom right, I believe it's the biggest well on there. It's the Sandra Jean. So we have a lot of great experience drilling the Avalon. We know it's sour. We know the variations and how much H2S is present. We have a good understanding of CO2 and other inert gases, and we are prepared for it. We've drilled the Avalon all through Lee County at EOG. We knew it was sour. We stopped drilling it because it was sour to put sour gas gathering in place. When we started Avant, we partnered with a midstream gathering company specifically designed to take sour gas in this area, which allowed us to drill the Sandra Jean well. We are currently drilling the Quail Avalon wells and number 11 there. There are 6 wells per section, 1 mile laterals. It also allowed us to drill number 12, the Lee unit wells, which are 6 wells per section spacing. They're also permitted the rest of the Lee unit at 8 wells per section spacing. All that to say is we love the Avalon. We've drilled it in Avant 1. We're drilling it now in Avant 2. There are a lot of other operators who also love drilling the Avalon in this area. So this was put together to refute their declaration that the Avalon is not prospective in this area.
Thank you. And in your opinion, does this, the fact that Permian has determined that the Avalon is not prospective in this area, does that have a negative impact on Avant's correlative rights?
Yes, they're planning to leave those reserves behind by not actively developing them.
Let's turn to your next rebuttal slide, which is slide B2. Are you seeing that slide on your screen?
Yes.
Not sure why I'm getting so much feedback right now. I'm going to just keep turning my mic off and on to avoid the feedback. But really quickly, would you mind, or would you be able to tell the division why you prepared Avant rebuttal exhibit C2?
Yes, Permian Resources made a version of this slide. We replicated it as best we could. And what it showed is Permian Resources' great position in this area as being dominant and in contrary, our very little exposure to this area. I believe they showed only a couple of units that they attempted to find Avant operating to information. However, I feel like they either intentionally or not, or unintentionally, I don't know, but I think they didn't look hard enough at Avant operating to specifically the triple stamp pooling order, which is literally adjacent to this unit. They left out. They also reference our Avant operating 1 position many times in their direct. So since they referenced it, we put it on this map to show in gray our previous position that Coterra purchased, basically just depicting that, we have a lot more experience in this area than they intentionally let on.
Thank you. And now let's turn to rebuttal exhibit B3. And are you seeing that part of that anyway on this slide? Well, there we go.
There it is. Yes.
And would you explain to the hearing examiners why you prepared rebuttal exhibit B3?
Yes. After reviewing their exhibits, their proposed surface locations, pads, CTBs, flow lines differed greatly than what was previously provided to Avant operating. So I wanted to address the difference there. And this slide kind of shows a timeline, but basically in their own testimony, Permian Resources Spicy Chicken BLM on-site was as far back as August of 2023. In common course, whenever you're in the drill island, potash drill island area, surface locations are limited. So when other operators propose pads or propose CTBs or propose pipelines in the vicinity, it is customary to notify offset operators of, hey, we're going to try to put a CTB here. Hope this doesn't interfere with your plans. And that's what the email at the bottom left from Jim Rutley from the BLM dictates is Civitas, which is directly north of Spicy Chicken, was planning a CTB. So Jim Rutley notified Avant, Permian, and ConocoPhillips, which are the offset operators of this activity, to make sure they weren't affecting our plans. Roger Lowry, which is from Permian Resources in the top, promptly responded on October 20th, 2025 of, Jim, none of these proposed CTB locations will impact our Spicy Chicken pad plans. And then I took a screenshot of the attachments that Roger Lowry from Permian Resources attached. And that's what's depicted on the satellite view below. It shows 4 distinct Permian Resources pads, and I believe 1 CTB and a plethora of pipeline across the whole area. So this was, Roger Lowry was at Avant's BLM on site in September of 25 or September of 2025. Roger Lowry, a month later, supplied PR and others their proposed plan on October of 25. And that was the last we ever heard of anything about Permian Resources plan. We had no reason to think that this plan has changed. So we put a slide together that shows the cost differentials of all these pads and how much surface disturbance it would be, unnecessarily so. And then we got their exhibits and saw that they now proposed 2 pads and 1 CTB, which is contrary to what they provided us. It actually looks very similar to our plan that they were present for, nearly identical, if you will. And this was just kind of show why we interpreted their plan originally, because that's how they gave it to us, and trying to answer why they changed it. And we also found one of their own C102s updated in April of this year. I don't know what that's about, but it seems like their plan is ever changing and looks like it's very similar to our plan.
Thank you. A moment ago, you referenced the email from Mr. Rutley at the BLM to Avant and PR identifying the changes that Civitas was proposing. Do you recall that?
I do.
Is that an email that you would have expected to see as well, a communication from BLM if Permian Resources had changed its surface facility location?
Absolutely. A change of that magnitude would definitely warrant a follow-up email, even potentially a re-onsite, if you will, changing from 4 pads to 2 pads. And especially it would warrant at least an email, if not a re-onsite, if their new pads directly overlap our pads.
And as a competing operator, would you be entitled to notice of those changes?
Yes.
Those are the only questions I have. Is there anything you wanted to say before I pass you to for cross-examination?
I don't think so.
Thank you.
Ms. Hardy?
Yes, thank you. Good morning, Mr. Harper.
Good morning.
It's good to see you.
You as well.
Regarding the depths of Permian Resources applications and the wells that they're pulling, all of the wells are in the depths being pooled other than the Second Bone Spring shale wells in case numbers 25833 and 25844, correct?
Correct.
Okay. And the tops and bottoms of formations are subject to geological interpretation. Wouldn't you agree with me?
To some degree, yes.
With respect to your direct testimony and exhibits, can we share? Please stop sharing. You agree that the Avalon in this area produces significant amounts of H2S, correct?
It produces H2S, yes.
And has Avant at this point evaluated the amount of H2S?
We have a general understanding of how much H2S it should produce, yes.
And is that amount significant in your opinion?
Yes.
And as you sit here today, does Avant have facilities in place to address the amounts of H2S in the Avalon at this location?
They are in process, not in place.
Let's look at paragraph 22 of your direct testimony affidavit. And you state there that Permian Resources' failure to develop the Avalon leaves reserves behind, correct?
At this time, yes.
And I think you said earlier in response to Ms. Bennett that Permian Resources has determined that Avalon is not prospective. Do you recall that testimony?
Yes.
Permian Resources doesn't actually say that the Avalon is not prospective, do they?
I would have to reference their slide. They reference the degradation in reservoir quality. I don't know. You can turn to the slide if you would. I'd like to look at it.
Well,
Am I
I guess I'm
entitled to look
asking
at it?
from your I'm not sure which slide you're referring to.
Um,
You can point me to it.
yeah, give me 1 second. I'll gladly find it. I think it's B20. Graph B20.
And that slide, it doesn't say that the Avalon isn't perspective, does it?
Not verbatim, no. Focusing on the degradation of rock quality would, in my opinion, imply the lack of prospectivity in their opinion.
Permian Resources could develop the Avalon later, couldn't it?
I don't know. I don't know if they can.
Well, if it determined that the Avalon was perspective, it could develop it, couldn't it?
If they chose to, potentially, yes. If they have the right infrastructure in place and are able to handle it, or
Avant's Cutbow development is approximately 2 miles to the north, correct?
approximately, yes.
And Avant did not develop the Avalon at Cutbow, did it?
Oh, we did not get a chance to, no.
And in paragraph 23 of your statement, if we can go back to that. You state there that Permian Resources' failure to develop the lower Wolfcamp leaves reserves behind, correct?
At this time, yes.
Permian Resources could develop the lower Wolfcamp later, couldn't it?
Potentially.
And again, regarding the Cutbow development, Avant did not develop the lower Wolfcamp at Cutbow, did it?
We did not get a chance to, no.
And your testimony and exhibits don't discuss Avant's Alpha Wolf or Grayling developments, do they?
I mean, Gotera's Alpha Wolf for Grayling developments? I believe the Grayling unit is referenced in the Avalon rebuttal slide I just spoke on.
And those units are approximately 7 to 10 miles north of this area, right?
Approximately.
Let's look at your rebuttal exhibit B1 regarding the Avalon. And this is one of the slides, or the slide you're using to show that the Avalon is perspective in this area, right?
Yes, ma'am.
Okay. And this slide shows permitted wells, correct?
Among others, yes.
Yes. And permitted wells may or may not be drilled, correct?
I guess, I mean, operators spent money to permit these wells, so they obviously plan to drill them, but technically they have the option to pursue drilling or not.
And in fact, Avant did not drill all of the wells that permitted at Cutbow, correct?
We did not drill the 503H. Yes, I believe so.
Isn't it true that Avant did not develop 3 of its permitted wells at Cutbow?
I wouldn't know off the top of my head.
So you don't recall?
I do not recall.
And your exhibit here also includes drilled but uncompleted wells, right?
Correct.
Those are the wells you reference as ducts.
Yes.
And in fact, of the developments that you show here, and I'm going to refer to the numbers, only numbers 7, 9, 12, and 13 include currently producing wells, right?
7, 9, 12, and 13. Yes, I believe that is correct in terms of currently producing wells.
And number 7, which is MRC Gavilon, is the closest development that you show here to the spicy chicken development, correct?
Of a producing Avalon well, yes.
And in that development, isn't it true that only the parent well is producing?
I believe so. I believe they have additional permits for filling the Avalon in that section or unit.
And that well is about 5 miles away from spicy chicken, right?
4 or 5, yes.
And the other producing wells shown on your map are more than roughly, I think, 12 miles away. Is that correct?
I would refer you to the Sandra Jean, which is the larger well on the data set, if not the largest. That is closer to 5 or 6.
And I've got multiple screens here. So Sandra Jean.
Number
is
9, sorry.
9. And if we're calculating the distance,
Roughly 5 miles, I would say.
5 to 6. Okay. And at Sandra Jean, only the parent well has been drilled there, right?
Correct.
The closest Avalon well to spicy chicken that's been produced is the Big Eddie Anakin 203H, right?
I would disagree.
What?
How far away is the Anakin well?
About 4 miles based on the slide here. And you can see it in the bottom right of your exhibit.
Could we pause for a moment? I'm not sure who's testifying right now. You shouldn't ask questions to the attorney.
Oh, sorry. I was just trying to find where she's referencing.
No, that's okay. That is a way of saying, I don't know where you're
Okay.
referencing and letting her do it.
Apologies.
We have to be careful that we create a record that is accurate. And what the attorney says is not evidence, but what you say is evidence.
Okay.
So could we go back? Is there any way to strike that last exchange?
You have.
Then please strike that last exchange. So when you ask that question, we're going to strike that and the answer. So now let her know that you don't understand where it is and let her help you, but it's not testimony.
Understood. Sorry.
Go on.
I don't know how far away the Anakin well is.
Okay. And we can zoom in here. It's a little bit blurry, but it's on the bottom right of your exhibit. And there you're actually showing Permian Resources exhibit.
Yeah.
Correct.
Oh, yes, I see it. Yes.
Okay. And if you look at the Big Eddy well, we could also go to Permian Resources exhibit. That would be more clear, but it's shown there approximately 4 miles from spicy chicken. Is that fair?
Sorry, I'm having a hard time seeing it. For me, it looks like that would be roughly 5 miles to the west. And it looks like the Gavilon well be roughly 4 miles to the east. I'd say the Gavilon well looks to be a little closer than the Anakin well you're referencing.
Ms. McLean, can you pull up Permian Resources exhibit? You can tell because I think it provides a clearer image.
And which exhibit number are we going to be looking at?
C9.
C9?
Yes.
Do you have a copy of C9 in front of you?
Yes, sir. I just found it.
Okay. Is it clearer?
Yes, sir.
Okay, so I think we're ready to go.
On that exhibit,
Okay, I see it now.
does it show that it's
I would agree with PRC9 that they are both 4 miles away. Anakin being 4 miles-ish to the west and the Gavilon being 4 miles-ish to the east. Equidistance.
the Big Eddy Anakin well only produced for about 3 months? Is that correct?
It appears so, yes.
And then it was plugged. right?
Yes,
And that well is not shown on your exhibit that we were just looking at, correct?
I don't believe so. I don't believe I went that far west.
If we could please turn to paragraph 9 of your rebuttal statement. And you state there that Mr. Higginson's exhibit C4 regarding Avant's acreage position is too narrow, correct?
Yes.
And then let's look at your rebuttal exhibit B2, which is your map of the acreage positions of Permian Resources and Avant. Okay. And initially, I wanted to make sure I'm correct. The scale is different that you provided here for Avant versus Permian Resources, right?
In terms of like the spatial distribution between the
Yes.
two maps, I believe so. It's hard to exactly replicate Permian Resources slide dimensions, but we tried to.
And you've designated as Avant acreage lands that are currently operated by Coterra, right?
Currently Coterra, previously Avant, yes.
Of all the acreage you've designated as Avant's, only the blue acreage with black boxes is currently operated by Avant, right?
The blue acreage in black boxes, Avant has operations in, yes.
Okay. And those are the only operations Avant currently has in this acreage, right?
In this map view, I believe so. I could be missing some vertical wells, but I believe this covers most of Avant's current operations, inclusive of the 17 wells we're currently drilling.
Okay. And when Ms. Bennett was questioning you, you mentioned the triple stamp pooling order. Do you recall that?
I do.
Okay. And Avant doesn't currently have permits for those wells, does it? The triple stamp wells?
I'm not sure if they're approved yet or not, to be honest with you.
Certainly they haven't been drilled.
They have not been drilled, no. They have submitted, if not approved, permits.
In paragraph 15 of your rebuttal statement, we could turn to that. You state that Avant did not receive notice of a change in Permian Resources surface facilities, correct?
Correct.
And you also state that surface changes of this magnitude may require an additional onsite with a BLM, correct?
Like I said, they should require, given the magnitude.
Well,
Oh,
actually,
so in the statement.
the testimony,
Oh, yes, I see it.
and there you stated may, right?
Correct.
And here Permian Resources is significantly reducing the size of its surface facilities, correct?
It appears that way, yes.
Those are all of my questions. Thank you.
Thank you, Ms. Hardy. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Harper, can you please describe for me where the depth severances occur within the Bone Spring Formation?
Yes. Sorry, let me try to find a good slide to reference. I think I can talk off of exhibit B8. And I apologize, I don't have the exact depth definitions to define the depth severances. If Ms. Bennett can give me the depths, I can identify them if that's what you're asking.
Mr. Harper, I guess what I'm asking is, let me maybe better define my question. Are the depth severances related to a particular top of a formation or a subset of a formation?
Yes.
And what top are they related to?
And there's second, I don't know if I'm answering the question right, Mr. McClure, the second bone spring interval that they've defined, is that what you're asking?
Well, let me re-ask my question, I guess. Is it accurate that there's a depth severance within the bone spring for which the top and base of is both within the bone spring?
Sorry, can you repeat that question one more time? I apologize.
Would it be accurate to say that the second bone spring interval has a different set of ownership than the rest of the bone spring?
Yes, I believe so for Permian resources. I'm not sure I'm qualified to answer about interests variance.
I asked Miss Saratinos about this, and she referenced you, Mr. Harper, as being the expert to ask. So is it accurate to say that you can provide me these additional details as to where the depth severances occur?
I believe so. I'm sorry, I'm struggling to understand the question fully, but it appears that the depth severances might fall within the second bone spring shale or second bone spring sand interval, or second bone spring interval, I guess is a broader sense.
Well, I'll provide additional context, I guess.
Okay.
My interest here is, does the depth severance occur at the top of the second bone spring sand or the top of the second bone spring carbonate? Do you have an answer to that?
If I had the depths, I could be able to identify them in terms of whether it's the shale or the top of the second sand, but I don't have the depths themselves right in front of me, unless I'm missing them somewhere. Or if there's an exhibit that defines the depths themselves, then I can identify where exactly they fall.
Did you assist Avant in deciding which intervals it would like the division to force pull for these cases?
Yes.
And how did you make those determinations?
Based on the prospectivity of the target intervals or the formations at the time.
So how was depth severances considered in that review?
We proposed to pull the first bone spring sand across the 960 and the second bone spring sand across 640 based on existing depletion to the south and ownership. Does that answer your question?
How does Avant know what the ownership is in each of its proposed units if it doesn't know where the depth severance occurs?
I just don't have the depth severances in front of me at this time. I don't remember the exact depths that the depth severances are referring to.
Do the depth severances refer to specific depths or do they refer to formation tops?
I believe I've seen them at specific depths, but I don't have that in front of me.
Mr. McClure,
Yeah, Mr. Hearing Examiner, go ahead.
I've heard the witness repeatedly say that he doesn't have certain information to be able to answer the question. So let me interject for a moment. What would it take for you to be able to answer the questions accurately?
Just to have the actual TBD depths that identify the depth severances, just so I can reference them on the appropriate log.
And are those available to you?
I believe Ms. Bennett might have them available.
Oh, you have them. Okay. I didn't know that anyone had them. So maybe this would be a great time to break for lunch. It's 11:45. That way, Ms. Bennett can give the witness this information. We'll ask you about what you've been given.
Okay.
Ms. Bennett, please make sure that Ms. Hardy and Ms. McLean see whatever you're giving them so that they can object to it if they so choose. How long do the parties want for lunch?
I would say about an hour and a half, just because we have to drive to a place for lunch.
Oh, you have to travel.
Well, there's nothing right around here. I guess we could go to Trader Joe's for lunch.
Well, it's true. And then there's some restaurants right across from Trader Joe's. There's an Asian place, a Vietnamese place. There's also a Middle Eastern place right across the street. There's Maria's. I don't know if they're open for lunch.
Sounds like you have a lot of good recommendations.
Well, I mean, I just know that they're there.
Maybe in an hour then. I just wasn't thinking about all the places that are close by, but also interested in there.
They probably know as well, but what do you want?
I think until 1 would be
Oh,
fine.
an hour and 15.
Yes.
Okay, perfect. And there's places to eat right over there, right? Okay, all right. Or you could buy something and you could heat it up. I think we have microwaves here in the building. If you want to use one, you're more than welcome to. That goes for anyone here. Okay, Mr. McClure, are you okay with 1 o'clock?
Mr. Hearing Examiner, yeah, I'm fine with that.
I know the court reporter wanted 30 minutes, but we didn't even come close to 30 minutes. I really don't care. Okay, so that being the case, which witnesses do we have with us? I'm sure everyone traveled from somewhere. Which witnesses that are here now have a flight out at the end of the day? I see 2 raised hands.
Me as well.
Oh, I'm sorry, I didn't see.
Sorry.
So basically, Avance witnesses all need to fly out. Well, good, then I'm glad you're putting on your case first. And we're, more than halfway through. So I think we'll get you on the plane later today. Okay. Anything else before we break for lunch? I do want to raise something.
Me too.
Go ahead first.
I was just going to return back to the Coterra case, 25813, that you said was not going to be heard this morning, but could be
Until-
heard later this afternoon.
Is 1 o'clock okay?
One of our witnesses is not available at 1 o'clock today. He's available starting at 1:30. So
Okay.
maybe I don't really want to know if we want to take a break at 1:30 to return to that case. So whatever the division's preference is.
And I know Mr. Rankin had a case and he sent an email a while ago, and Mr. Rankin is 1 o'clock. Okay, I don't know if you're still with us, Mr. Rankin, but maybe Freya, you could send Mr. Rankin an email.
Yes, I will.
You know what? I tell you what I'd like to do. We're going to come back on the record at 1:15. Okay, 1 hour from now. You don't have to be here, but we'll hear Mr. Rankin's case at 12:45, and we'll be ready for this case to continue at 1 o'clock, unless you come back earlier, and that's fine too. Mr. McClure, would that be okay with you to hear Mr. Rankin's case at 12:45?
Yeah, Mr. Hearing Examiner, that's fine with me.
That's fine with you. And Mr. McClure, do you think, because if we don't need to have Ms. Bennett's witnesses and we're going to take the case under advisement, which I don't know that we're going to do, Mr. McClure, you could let me know that now as well, and we could hear that at 12:45 as well.
I can't speculate on
You don't
that
know?
for sure.
Okay, all right.
Yeah.
Well, it's a possibility. We'll come back on the record at 12:45. If Mr. McClure says that the case can be taken on advisement, you don't have to worry about your witnesses being available. If not, then maybe tomorrow. Okay?
Is there another thing that you wanted to address? with me?
Yes, there is. And it was the motion you filed. And it just
Okay.
it
Right.
occurred to me.
Yeah,
that-
me too.
Right. It occurred to me, and I don't know how Ms. Hardy or Ms. McLean feel about, did you see the motion?
They did.
They didn't see it?
No, they did.
Oh, they did. They're
It's the
shaking their heads
motion
no.
to.
This was a few days ago.
Mhm.
I haven't ruled on it.
What is the motion?
The motion to dismiss certain wells out of the application.
Oh, their
Yes,
motion.
their
Okay.
motion. Sorry.
I was like, what?
I'm sorry. It's my fault. So I was not comfortable dismissing the wells on my own without evidence. Okay? And I don't know why Avant can't just file a notice of dismissal without having me file an order dismissing those wells. Is there a reason?
Not that I can think of off the top of my head. I was just following the same
Right.
process that
I
was
saw that.
directed to do the last time.
I saw that. So I know that you said that we've done that before,
Mhm.
but I wasn't even sure that I actually signed an order in that case, but you're saying I did.
You did.
Yeah.
Mhm.
I don't see the need for it. So unless you're going to make an argument, you can do it tomorrow or later today about why I need to dismiss wells from your application. I think it's better left to you to do that on your own. So just wanted to address that for now.
So I did file a motion. So
Yes.
are you suggesting that all I need to do is file a notice to remove the wells, or what is the?
I'm not suggesting anything that you should do because it's not my place to give out that kind of advice. However, I think you should do whatever is in the best interest of your client, and you know far better than I what's in the best interest of your client. You are already going to be filing amended exhibits as it is, right?
Mhm.
And I don't know if you could take care of that dismissal through a notice of dismissal, and then you amend your CPAC or whatever it is that you need to amend to show that those wells are not there anymore. That's really up to you.
Okay.
As long as it's not objected to by Permian, and so far I'm hearing the shaking heads, but that I don't know, who knows what will happen later, but that's my feeling so far.
Thank you.
And I
And,
don't need to be involved in that.
okay, thank you.
So let's all have lunch and we'll be back at 12:45. Whoever wants to be here can be here.